Welcome to This Explainer. Okay, let's just dive right into this, shall we? Today, we are stepping inside the absolute apex of the trial court hierarchy in the Pakistani criminal justice system. We're talking about the Sessions Court. Now, to be clear, this is definitely not where you go for minor property disputes or, petty theft. Not at all. This specific court tries the gravest, most serious offenses on the books: murder, terrorism, kidnapping. We are talking about the kinds of crimes that carry life imprisonment or even the death penalty. And because the stakes literally could not be any higher, the procedures you'll find here are incredibly elaborate, deeply formal, and highly, highly consequential. I mean, think about it from the perspective of a criminal advocate. Walking into this courtroom means carrying the ultimate responsibility. They are quite literally defending their client's right to continue breathing. Every single procedural misstep, every dropped objection could literally mean the difference between freedom and the gallows. So here is our roadmap for today. First, the gateway to the Sessions Court. 2, how the prosecution strikes first. 3, the defense and the verdict. 4, we'll dive into qisas, diyat, and pardon. And finally, number 5, offenses against the state. All right, Section 1, gateway to the Sessions Court. Let's see how this all begins. Now, you might actually assume that a massive high-profile capital case just goes straight to this apex court. But interestingly, the Sessions Court usually doesn't take a case directly. It relies on a procedural filtering mechanism known as commitment. So, step 1 is the magistrate inquiry. If a lower-level magistrate is looking at the facts of a new case and realizes, wow, this crime is way too severe for my limited sentencing powers, they immediately move to step 2, which is the commitment to the Sessions Court. But, and this is a really crucial point to remember, this commitment is purely a procedural step just to move the paperwork along. As the Supreme Court noted in the Akbar Khan case, committing a case is not a finding of guilt. It simply means the case belongs in the more serious form, period. Once it finally arrives there, step 3 happens. The state's public prosecutor formally opens the case, laying out the initial allegations. And finally, step 4. The formal charge is framed and read directly out loud to the accused, which officially kicks off the trial. So once that formal charge is read under Section 265C of the Criminal Procedure Code, the accused is asked a very simple standard question. How do you plead? But here is where things get really intense. In capital cases, meaning cases where the death penalty is actively hanging over the defendant's head, the court cannot and absolutely will not just rubber stamp a guilty plea. The Lahore High Court has explicitly ruled that a guilty plea in this context requires extreme caution. The judge has to meticulously scrutinize the plea. They have to look the accused in the eye and ensure they truly, deeply understand the fatal consequences of what they are saying. The judge has to be utterly convinced that there is zero police duress, no coercion behind the scenes, and that the physical facts of the case actually match the charge being pleaded to. A perfunctory, robotic acceptance of a guilty plea here? No way. That's considered a massive legal irregularity that can trigger immediate appeals. The whole system is basically designed to protect the accused from throwing their own life away under pressure. Moving on to Section 2, the prosecution strikes first. The trial is now fully underway. The prosecution walks into the room armed with some incredibly heavy-hitting tools, led, of course, by a government-appointed public prosecutor. Now, as a quick aside, it's worth noting their job isn't technically to win at all costs, but rather to assist the court in uncovering the truth. So as they bring in their own witnesses to testify, a process we call the examination in chief, the judge has a very specific, incredibly demanding duty. Unlike lower courts where a judge, actually, scratch that, even in lower courts they take notes. But here, the sessions judge must record this witness testimony verbatim, word for word, exactly as it is spoken. Why? Because if there's an eventual conviction and an appeal, the higher appellate courts are going to rely entirely on this written record. If a judge were to just summarize or abbreviate the testimony, they might accidentally leave out the exact phrasing, or maybe a slight hesitation, or a super specific detail that might actually prove innocence or guilt. A summarized record could ruin the entire trial. It has to be exact. Okay, now we get to one of the absolute most potent pieces of evidence the prosecution can possibly present. It falls under Article 46, and it's called the dying declaration. A dying declaration is an account given by a victim about who attacked them right before they pass away. And the Supreme Court has consistently ruled that if the victim was conscious, coherent, and the statement was recorded properly, usually by a medical doctor or a magistrate, it carries a chillingly high degree of reliability. In fact, it's so powerful that a strong dying declaration can sometimes sustain a murder conviction entirely by itself. No other corroborating evidence, no other eyewitnesses, just those final words. The legal presumption here is that a person standing right at the absolute threshold of death has absolutely no motive to lie. They are meeting their maker. It is quite literally the voice of the victim echoing from beyond the grave, pointing a final finger at their killer. But what about confessions from the accused themselves? Normally, a confession is recorded formally before magistrate long before the trial. But you get a massive amount of courtroom drama when we deal with what are called retracted confessions. This is when a defendant stands up in the middle of the sessions court and says, "Wait, I take it back. I only confessed because I was tortured by the police." So what does the judge do? Well, the court doesn't just automatically throw the confession out the window. Instead, it's treated with extreme caution. The judge will intensely look for independent corroboration, meaning they need other, completely separate pieces of evidence, like, say, a recovered weapon or a perfect forensic match, that independently prove the original confession was actually true. However, if the defendant claims they were tortured but has absolutely zero medical evidence to back it up, or if they didn't complain about the abuse at their very first opportunity, the court might completely disbelieve the retraction. If that happens, the judge can give that original confession full, devastating weight. Which brings us to Section 3, the defense and verdict. The prosecution rests, and the defense takes the floor. The defense typically spends hours dismantling the prosecution's case, right? Aggressively cross-examining so-called chance witnesses, or pointing out that a relative is an interested witness with a clear motive to lie. But eventually, this all builds to the ultimate strategic gamble for the defense team. The accused faces a massive, life-altering choice. Under Section 340 of the Criminal Procedure Code, the defendant can choose to testify on oath. They can take the stand and tell their own side of the story. But if they do that, they must face the brutal, probing cross-examination of the prosecutor. Or, alternatively, under Section 342, they can choose to make an unsworn statement and preserve their constitutional right to silence. And the Supreme Court is crystal clear on this. Choosing to remain silent cannot be used as evidence of guilt. The prosecution has to stand on its own 2 feet. They cannot use the silence of the accused to magically fill in the gaps of a weak case. And when the prosecution's case is weak, or based entirely on circumstantial evidence, the defense leans heavily on a truly brilliant legal standard. Let's say a murder case has absolutely no direct eyewitnesses. It's based entirely on circumstances, like someone being the last person seen with the victim, or maybe a muddy footprint found near the scene. In these cases, the court applies the golden thread rule. This rule dictates that every single circumstance presented must point strictly and unerringly to the accused's guilt. If there is any reasonable alternative explanation, any hypothesis at all where the accused might actually be innocent, the judge must acquit them. It is a phenomenally strict standard, meticulously designed to absolutely prevent executions based merely on suspicion or probability. In this court, you absolutely cannot hang a person on a maybe. So, we finally reached the climax of the trial. Step 1 is the closing arguments. This is an intellectually demanding battle where the prosecutor and defense clash over that beyond a reasonable doubt standard. Then, Step 2, the judge has to write a highly detailed, reasoned judgment. They can't just hand down a bare guilty finding. Without a deep, logical analysis of every single piece of evidence, the judgment will be immediately thrown out on appeal. And then Step 3, this is vital. If a death sentence is actually passed, it goes nowhere without high court confirmation. No execution can take place in Pakistan until the high court pulls up the entire verbatim sessions court file, reviews it, and independently confirms that the sentence is just. But what happens after that? I want you to consider this deeply provocative scenario. The trial is completely over, the high court has confirmed the sentence, the killer is literally sitting on death row awaiting execution. But then, out of nowhere, the victim's family decides they want to forgive the killer. What happens? Now, in many Western legal systems, the state carries out the execution anyway, because the crime is ultimately considered an offense against the state itself. But in Pakistan, this exact scenario introduces a massive, life-altering narrative twist. And that brings us to Section 4, Qiyas, Diyat, and Pardon. This is the unique Islamization of Pakistan's homicide laws. Chapter 25 of the Penal Code governs offenses against the human body. And right at the center of this is Qatl-e-Amd, which roughly translates to intentional killing or premeditated murder. Now, under this Islamic framework, the law prescribes 3 alternative consequences for this specific crime. First, there's qisas, which means equal retaliation, essentially execution. Second, there's diyat, which is financial blood money. And third, there's tazir, which is discretionary state punishment, like handing down a standard 25-year prison sentence. This framework completely transforms the dynamics of a murder trial because it fundamentally shifts the balance of who actually holds the ultimate power to punish or to forgive. So who actually holds that power? It isn't the judge, and it isn't the prosecutor. It's the wali, the legal heirs of the deceased victim. They hold all the cards. They essentially have 3 choices. First, they can demand qisas. This means they insist the state goes ahead and executes the killer in retaliation. Second, they can accept diyat. This is financial compensation, and if they accept the money, the execution is formally waived. Or third, they can grant a pardon, known in the law as afwa. This is where the killer is forgiven outright, without money, entirely extinguishing the qisas death sentence. So think about that. The final fate of the accused quite literally rests in the hands of the victim's grieving family. It makes for an incredibly profoundly victim-centric justice system.
So let's say the family chooses the second option, diyat. How much is a human life legally worth in this system? Well, the law actually sets a strict baseline using this exact number right here, 30,630 grams. That is the exact amount in grams of silver used to dynamically calculate the legal blood money. Now, you might be wondering, why silver? It's brilliant, actually. It ensures the financial value always scales with today's market, constantly protecting the victim's family from inflation. The court takes the current market price of exactly 30,630 grams of silver to determine the absolute minimum rupee amount that must be paid. But listen, it must be a genuine, willing financial settlement. If a wealthy killer tries to financially coerce or threaten a poor family into accepting pennies on the dollar, the Supreme Court can and absolutely will step in to declare the whole agreement void.
Which brings us right back to our death row question. The Supreme Court ruled in the landmark Ghulam Qadir case that compounding a murder conviction extinguishes the qisas sentence at any stage of the legal process. Any stage. This means if a genuine, strictly uncoerced pardon is verified by the court, it can literally pull a prisoner right off death row even hours before the execution is scheduled. The family's constitutional right to pardon, explicitly and completely, overrides the state's initial death sentence. Now, caveat here, the state does retain residual tazir power, meaning if the murder was a brutal, shocking threat to wider public order, think of a notorious serial killer, the judge can still impose heavy jail time to protect society. But the death penalty by qisas? That is completely, permanently wiped out by the family's forgiveness. Finally, Section 5, offenses against the state, or pivoting from personal homicides to crimes that threaten the nation itself. We're talking about the heaviest, most politically charged offenses in the entire legal system. First up is high treason, falling under Article 6 of the Constitution. This involves abrogating or subverting the Constitution by force or even the show of force. It is so unimaginably serious that it's tried by a special court and carries the death penalty. Then we have sedition, under Section 124A. This is defined as exciting disaffection or hatred toward the government. But note this carefully. Appellate courts have increasingly and strictly ruled that this requires inciting real, actual violence. You cannot legally be charged with sedition just for peacefully criticizing state policy on Twitter. And finally, terrorism, governed by Section 6 of the Anti-Terrorism Act. Now, terrorism cases are actually ripped entirely out of the Sessions Court and handled in a parallel system of anti-terrorism courts, or ATCs. These courts have incredibly strict, harsh rules, like allowing up to 30-day police remands and demanding rapid, sometimes back-to-back trial timelines that move at lightning speed. But as you might imagine, having this parallel system creates a massive ongoing jurisdictional battle. Because what exactly is the boundary between an ordinary murder and an act of terrorism? An ordinary murder born of a personal dispute, maybe a robbery gone wrong, or a bitter family feud, that clearly belongs in the Sessions Court we've been talking about. But terrorism belongs exclusively in the Anti-Terrorism Court. So what happens? Sometimes, police or prosecutors will aggressively file terrorism charges for a completely normal, everyday murder just because it happened in a crowded marketplace, or maybe just because it involved a firearm. They do this attempting to use the much harsher, much faster anti-terrorism trial procedures to secure a quick and easy conviction. And this is exactly where the Supreme Court vigorously pushes back to protect the integrity of the justice system. In the famous Tariq Butt case, the court made it abundantly clear, without the specific design to overawe the government or to strike profound terror into the general public, a killing is just ordinary murder. It doesn't matter how brutally or publicly it was committed. The system strictly prevents normal crimes from being prosecuted in parallel terror courts just for convenience. The psychological intent behind the crime matters just as much as the physical action itself. If the underlying motive is just a personal dispute over money or a piece of land, the Supreme Court will strip the terrorism label right off of it and send it right back down to the Sessions Court where it belongs. So, we've covered a lot of ground today. We've seen the gateway to the court, the intense verbatim procedural rigor required of the prosecution, the defense's strategic gambles, and the rigid jurisdictional boundaries of state crimes. But I really want to leave you with a final thought to chew on. On one hand, you have the incredibly rigid golden thread of evidence, a standard that demands almost scientific, objective perfection to convict someone of murder. But that exists right alongside a highly subjective, deeply emotional, victim-centric system where a grieving family holds the absolute, unquestionable power to pardon a killer right off of death row. When you combine these two massive extremes under the single roof of the Sessions Court, where does true justice actually lie? Think about that. Thank you so much for joining me for this explainer, and keep learning.